I'm John Vecchione, Senior Litigation Counsel at New Civil Liberties Alliance. And with me today to discuss the FTC and what might be in store for its powers and litigation against it is Cynthia Crawford. And Cindy and I have worked together before, but she received her JD from Georgetown University Law Center, an MA in American Government from Georgetown University, and an MBA from Johnson School of Management at Cornell University. And unusually for an attorney, a BA in Applied Mathematics from the University of California, Berkeley. She practices in Maryland, Virginia, and DC. And she is currently Senior Policy Counsel with Americans for Prosperity Foundation, focusing on regulatory issues, freedom of expression, and educational freedom. Before that, she was Senior Litigation Counsel with Cause of Action Institute, where she focused her practice on defending clients against government overreach, with an emphasis on constitutional protected individual rights. And before that, she was in private practice at Nixon Peabody and LeClaire Ryan. She's counsel record for AFPF's amicus brief in support of petitioners in lieu, and for Cause of Action Institute's amicus briefs in support of petitioner in Publishers Business Inc. v. FTC and AMG Capital Management LLC v. FTC. So welcome, Cindy. I'm glad to have you here. Now, our topic today is what's in store for the FTC. Given some of the Supreme Court's rulings on the Security and Exchange Commission this year, SEC v. Liu, and also Seila Law, us who practice in this area know that the FTC often cites SEC precedent to expand its powers. I wonder if they will be citing it as energetically to limit its powers. We'll see. But there was, the FTC has broad powers, both statutorily and then some that they've just asserted with, until recently, court acquiescence. They have an antitrust authority, and they split that with the Justice Department, and they can bring your company into an antitrust suit in their own agency or in administrative hearings, and don't have to go through every bells and whistles of proof that the Justice Department does. In addition, they've taken on the portfolio of online security, data security, and they do that under their authority to police unfairness, which has had great consequences across the American economy. So with that, I'd like to ask Cindy, what happened in SEC v. Liu, and what consequences might that have for the FTC going forward?
So the issue in Liu was whether the SEC can get monetary relief under the heading of equitable relief in their enforcement actions. Now, the SEC has been sort of the beachhead for a variety of agencies for getting monetary relief. And in this particular case, they were discussing the monetary relief in terms of disgorgement. When we get to the FTC discussion, it'll become more obvious why the particular phrasing is important. But the SEC in particular was seeking disgorgement, and the court issued its opinion on that basis and held that in the SEC's statutory context, disgorgement is a form of equitable relief that the SEC can pursue. And then they went forward to give some limitations on what that disgorgement may look like. And in that particular case, the relevant portion was that disgorgement has to be limited by legitimate expenses. So basically, if the person is running a business and they've spent part of the money that they brought in, if they spend it on something legitimate, then they get credit for that, and they don't have to disgorge money that they've already spent.
And I also think it it seems pretty clear that the court thinks that the money should be going to injured parties.
Right. So if you look at the beginning of the opinion in the syllabus, they particularly talk about and give the impression that the money is going to be going back to injured parties. But farther down in the opinion, the court doesn't actually take a stand on whether it specifically has to be returned to an injured party. In fact, they say that it's not necessary for them to determine what for the benefit of investors means. And so while the implication is that the money should be returned to an investor, that's not actually part of the holding. So it'd be sort of interesting to see how that plays out.
And we mentioned AMG just after we announced this seminar, but before we knew, the Supreme Court took two important FTC cases on cert. We mentioned AMG. Why don't you talk about the two cases they've taken on cert that affect the FTC directly rather than sort of a bank shot from the SEC?
So the AMG case is, the petitioner in that case is the defendant, which is a company that had an enormous monetary liability imposed upon it in an FTC enforcement action. And AMG sought petition on the question of whether Section 13B of the FTC Act allows the FTC to seek monetary damages in federal court. And specifically in this case, it's by going to court directly, as opposed to going through the in-house administrative process and following the process through from beginning to end, getting a cease and desist order and so forth. This case is the FTC goes directly to court. They seek damages from a federal court under Section 13B, the theory being that because the FTC has authority to seek an injunction in certain cases, that all other equitable powers of the court flow from that, including various forms of monetary equitable relief. So AMG has framed up the question very cleanly. Just, does Section 13B allow the FTC to seek monetary relief? Now, the FTC, by contrast, brought its own petition for cert in a case coming out of the Seventh Circuit, in which the Seventh Circuit said, no, the FTC does not have that power under its statute. So the FTC brought its own petition, and they framed up the question a little differently. They framed it up as whether they have the power to seek an injunction that orders monetary relief, which is sort of an interesting twist on terms that heretofore have been relatively clear. So the court has accepted both of those cases and has consolidated them, and they'll be heard together.
And that was FTC versus Credit Bureau out of the Seventh Circuit.
Right.
And that case was kind of interesting because the Seventh Circuit disavowed all its earlier precedent on FTC powers.
Yeah, it was very interesting because the Seventh Circuit actually was the first mover in terms of expanding this power for the FTC. So by repudiating their own precedent, they've basically repudiated the entire basis for all the other circuits that then followed and expanded the FTC's. They basically gave the FTC their imprimatur on seeking monetary relief, and the other circuits followed. So now the leader has repudiated its own original case, and that's what caused the circuit split.
Yeah, and the Ninth Circuit's still following the old rule, although they did have some dissents. Judge Scanlon particularly wanted to look at this again because the statute says they have injunctive power. It's not even as broad as the SEC statute that said equitable
right.
power. So the court has taken this, they've consolidated the two questions. I I know that we put in Liu, NCLA put in a amicus brief. I think that there's going to be a lot of amicus support on all sides of these FTC cases because it affects an enormous part of our economy, and it's also important in administrative law to cabin the powers of the FTC to those the statute actually gives them. So, what is the approach, do you think, to having the Seventh Circuit's ruling upheld and the Ninth's overturned?
Well, my hope and my expectation is that the Seventh Circuit's approach will prevail, because from a pure textualist standpoint, they're the ones who have it right. From a practical standpoint, it could have a huge effect on the way the FTC proceeds, because at this point, when you look at FTC enforcement actions in federal court, the bulk of what they do is actually chasing the money. It has less to do with modifying the behavior of the defendant than it has to do with trying to achieve large restitution awards.
Can you explain that for people on the panel who might not litigate against the FTC? What do you mean by that?
Sure. So a sort of typical way the activities would flow is that the FTC goes into court on an ex parte basis, files a complaint under seal, files a motion for a temporary restraining order and the appointment of a receiver. The documents that they use in support of their motion for TRO tend to be boilerplate, very long, 8-9 pages of case citations that go to other cases, not the one that they have before the court, explaining that there are people in the world who are flight risks, which they then use to imply that the defendant in that particular case is a flight risk. And all of this is done under seal. The target doesn't even know that they're of interest to the agency. And then when the court grants the TRO, the appointment of the receiver, which basically turns the entire company over to the receiver's power, they also then will freeze the assets not only of the company, but also of individuals if they think that an individual has received some sort of benefit from the company. So it may be an owner, it may be an officer. In some cases, they'll go so far as to freeze the assets of a person who's another step removed that they think may have received some sort of benefit from the company. And the way the defendant finds out about this is when either they realize that their accounts have been frozen. So for example, payroll doesn't go through. They may find out that their payroll account has been frozen. Or they can find out when the FTC shows up at their place of business with law enforcement and walks through the door and says, "We're taking over." So all of this is designed to quote unquote preserve assets. So if they weren't seeking money, there would be no reason to do all these cloak and dagger activities, filing the motion for TRO under seal and so forth. All of that is to maintain the element of surprise and then to put the receiver in to take over ownership of the company, control of the assets, and to avoid a potential for dissipation.
And I would add one other thing. It strikes me, both of you and I work for nonprofits and represent clients pro bono, but a large amount of attorneys in this country want to get paid. And what are the prospects if an administrative agency has come at you or your company in this way? What are your prospects for signing up an attorney for the long haul?
Mm-hmm. Well, it's pretty slim. So, it's one thing if you have a major corporation, that's the target. But the real risk is to the small and medium-sized business, where the FTC may come in with a multi-million-dollar demand. And if they get the asset freeze, the court will almost inevitably release some funds for defense costs, but if they're releasing a typical amount, which would be 10, 20, maybe $30,000 to take on the representation in a case where the fees could easily run over $1 million, depending on what discovery looks like. That's crazy for somebody to try to take on that kind of responsibility, not knowing if that $10,000 that's been allowed is going to be the end of it. Because every time the defendant needs more defense costs, that's another motion, that's another fight in court, it's another potential to lose, and it's another way of burning through that small amount of money that's been allowed in the first place.
And since you and I both agree that the FTC Act doesn't say that the FTC can do this, I mean, it doesn't say that you can get joint and several liability. It doesn't say that you can get monetary damages in this section, in 13B, when they go into federal court. There are others in administrative hearings that can then get enforced that monetary actions are allowed. But in this 13B context, which is really ballooned, it's really become the go-to action for the FTC. How did they get this power to get money and freeze all the assets of a company before there's any ruling on its liability?
So there are a couple of things that happen. One, there's the line of cases from the Seventh Circuit that they repudiated. And it started off small. It was very much of a foot in the door kind of scenario, where the courts looked at the FTC's ability to get an injunction. And they said, well, if you can get an injunction, then it makes sense that you should be able to potentially get an asset freeze. So let's hold the status quo. And, in the beginning, that wasn't too much of a problem because the FTC Act puts a time limit on how long a TRO can last before the FTC has to go in-house and start going through the process.
Temporary restraining order.
Yeah. So, but over time, this has expanded to, well, if you can get an asset freeze, what you really need is somebody to maintain the assets. So we're going to appoint a receiver. Well, that opens the door to a lot of changes because now you have a different person controlling the company. And now you have a person who has access to all of their records. And so the appointment of a receiver not only affects the control of the monetary assets of the company, but it also affects a whole bunch of evidentiary issues because you have a receiver who can go through their documents and then because they're standing in the place of the company can then release those documents to the FTC without, for example, going through counsel. So a lot of this flowed from a case from the 1930s, which was Porter v. Warner. And in Porter v. Warner, basically, it was a fairly narrow holding, but it's a holding that has spawned a variety of legal theories on what that case actually meant. So basically what happened in Porter was during wartime, there was a short time period law that allowed price controls on rent. And in that case, the court not only found for the tenant, but then also ordered the owner to repay the tenant for the excess amount that they were charged. And so one way of looking at this case is to say, well, it was a pure statutory read, because in that case, the statute allowed for quote unquote other orders necessary to fulfill the needs of the statute. The FTC has relied on the Porter case as a broader principle to say, well, a court can do basically whatever it wants in equity to make the plaintiff whole. But that's a deviation from Porter because Porter, the statute actually allowed for other orders, where the FTC Act does not allow for other orders. Now, other lines of case law have relied on Porter for that general proposition that a court always has inherent equitable powers to order whatever it needs to come to a complete solution, a complete resolution of the case. And so the Porter case, which was very narrow at the time, has taken on a life of its own, both in the SEC context and in the FTC context. So here we are.
So here we are, and I recommend the Seventh Circuit's Opinion and Credit Bureau to everyone who has an interest in this, because they do go through about how this really was a slippery slope or a camel's nose under the tent argument that got away from the statute and gave the administrative agency tremendous power over individuals and individual companies over time with no congressional input. Another aspect of this is, at least in the Porter case, somebody was getting money back, an actual party who'd been injured.
Right.
Where does the FTC now, as we sit here today, when they get these awards or settlements, do they have to find an injured party and return that money to them?
Well, the simple answer is sometimes, but it's actually a little bit more complicated than that, because if you go back to the elements of proof to demonstrate fraud, in a normal garden variety fraud case, when the plaintiff comes in, they have to show that there's been a representation and the representation was misleading and that they relied on it and that they were injured. And if they can't show injury, like any other case, they don't have standing. In an FTC case, the flow doesn't work that way. So basically, when the FTC comes in, they show that there's been a representation. They do not have to show that any particular person was actually misled by it. What they show instead is they show the representation to the court and try to convince the court that a person could be misled by it. And so if the court agrees that the representation could be misleading, then reliance is presumed. So that element is basically satisfied by default. And injury is presumed. So that's satisfied by default. And so if you have a company that has a lot of customers, that those presumptions then get multiplied by potentially thousands or millions. And then the sales price of each transaction is presumed to be the damages. And that's how you get to multi-million-dollar awards without actually having to go through proving all of the elements that an ordinary plaintiff would have to prove.
As for instance, in a contract claim, if you say, no, I got this widget and it didn't do what it was contracted to do, your damages are the difference between the widget you bargained for and what the widget you got does.
Right.
But in these FTC cases, it's just the price of the widget.
Right. So the FTC actually relies on a line of cases out of the Ninth Circuit that I like to think of them as sort of the cubic zirconia cases. So, you know, if you were a jeweler and you sold what you claimed to be a diamond and somebody relied on your representation, but you actually sold them a cubic zirconia, their damages would not be limited by the value of the cubic zirconia, because you basically, you sold them something different from what you said you were selling them. Now, in these FTC cases, what will happen is the seller may sell a product or service to the buyer. The buyer may be happy with it, and it may be exactly what the seller said they were selling. So there's no cubic zirconia issue there. But the FTC will still calculate its damages based on the entire sales price without giving credit for value delivered.
And the FTC, I think you've touched on this a little bit, but the buyer and the seller in these FTC cases, they could both be happy with the deal.
Right, they could both be delighted with the deal. In fact, there's a case now, which is the Online Trading Academy case. And I'm sure there are some people who are familiar with.
Why don't you explain what happened in that case? Just
okay.
If we don't know who.
So the Online Training Academy, just in brief, sells training to people who are interested in doing stock trading, and I think they do options trading as well, but it's basically an educational service. So if you wanted to learn to be a trader, you could sign up for a course there, you could sign up for a variety of courses and so forth. They have thousands of customers, and they've been around for quite a long time. The FTC brought suit against them under the Consumer Protection umbrella.
Where?
In, I think they're the Middle District of California, might be the Northern District.
But within the Ninth Circuit.
Within the Ninth Circuit, right. And so the idea is that not everyone who takes these courses actually makes money in the stock market. Well, okay. And you could say that about Harvard Business School, right? So basically the theory there is that the customers, the students, are being defrauded because they don't have a guaranteed outcome from the training that they buy. Well, the vast majority of their students are happy with what they're buying. They're so happy that over 3,000 of their students filed a motion to intervene in the court because they want their training back. And the reason that this is an issue is because, similar to what I was saying earlier, when the FTC comes in and they seek an asset freeze and appointment of a receiver, they interfere with the functioning of the business. And so in this particular case, the students are saying, I bought a course of study. I want access to it. The provider of the course of study wants to provide it. And so there's a private contract there in which the buyer and the seller are both happy. They want to go on with their lives. And the FTC has intervened saying, oh, no, you're not happy. we're going to stop this and save you from yourself.
Right. Or somebody, some construct is unhappy somewhere that we have in our minds. We don't have to actually show you. In fact, in that case, correct me if I'm wrong, that their attorneys use this circuit split to try and sue the FTC in the Seventh Circuit.
Right. Right. I think that is true. And I don't remember how the Seventh Circuit case turned out.
I don't know where it is right now either, but
you know, that case has another interesting overlay, which is that it raises an interesting free speech issue, which comes up in other FTC cases, but in this particular case, because it's an educational service, it's more acute, which is you have a speaker who wants to sell information, right, which is presented in the form of speech. You have a listener who wants to buy the information. And the FTC has inserted itself into this speaker-listener relationship simply because it's also a commercial relationship. And so it raises two very interesting policy questions, which is, one, when was the FTC ever contemplated to be the nanny for private transactions in which it declares that a willing buyer and a willing seller can't engage in this transaction because in the FTC's opinion, the buyer is better off without what they want to buy? And two, when was the FTC ever empowered to regulate a speech transaction in which somebody who wants to publish or provide information can be barred from making it available to a willing listener?
So this is just in the unfairness. This is an antitrust where we're used to government be able to come in and say, yeah, you're both happy with your conspiracy against the consumer.
Right.
This is when the consumer and the seller agree. I want to change tack a little bit, although I do think the OTA case, it is interesting that the FTC is obviously not bringing these type of cases before the Seventh. They want to get out of the Seventh Circuit as fast as their legs can carry them. And it does present a problem for companies that are either nationwide or in both places or in a number of circuits, because they may wish to be They may wish to have the Seventh Circuit precedent. The FTC obviously wants the other circuits precedent, particularly the Ninth. And I suppose this is the type of problem that the Supreme Court has seen to take the Credit Bureau and AMG, because they can see it happening before their eyes as lawyers assess and file. But I want to focus on another thing that happened this Supreme Court term, which is Seila Law, which was a concern the CFPB, the Consumer Products Protection Board, but it has some aspects affect the FTC, mainly because I'll set this up just so the viewer knows that one of the main administrative law cases allowing administrative agencies to do much of what they do is the Humphreys Executor's case. And in the CFPB, it was sort of, they'd taken everything. They'd taken every ability to sort of squish the executive and the legislative and the judicial, quasi-judicial, I think Humphreys Executor says, all into one mishmash and say, ta-da, no separation of powers problem. And the Supreme Court took that on this year in Seila Law. And could you just talk about what happened in that case?
Sure. So the Humphreys Executor case related to the FTC back in 1935, when it was an agency of limited powers. And the challenge was to the commissioner structure and the limits on the president's ability to remove commissioners, which is essentially the same question that was raised in the Seila Law case, because that again related to whether the president should be allowed to remove the head of the CFPB. But back in the day, in 1935, the FTC at that point was not doing enforcement actions. The basis for that case was that as an independent agency, it was supposed to be nonpartisan. The staggered terms of the commissioners were relevant, and it was deemed to be a quasi-judicial, quasi-legislative sort of hybrid animal whose job was to provide expert opinion to the court or to the legislature. And so it was an agency of limited powers. Now, we fast forward to today, the FTC has enormous enforcement powers, and in fact will characterize itself as a law enforcement agency. And so that puts it in a completely different posture from where it was back in 1935 when Humphreys Executor was decided. Now, in the Seila Law case, the court was very careful in its writing to compare the application of Humphreys Executor as applied to the CFPB to the way the FTC was structured in 1935.
What do you mean by that? Explain for a viewer. What do you? Was this time bound? What are they saying about how the FTC was and how the CFPB is now?
Well, I think to a certain extent that you were trying to avoid saying too much about the way the FTC is now, because Humphreys Executor was very specific to the time period, and it's really not representative of the way the FTC is now. And so applying that case to the CFPB is a different factual scenario from what we have today. Now, there's something interesting from the case, and I just want to read this line to you. This is in the opinion of the Seila Law. It says, the director possesses significant administrative and enforcement authority, including the power to seek daunting monetary penalties against private parties in federal court, a quintessentially executive power not considered in Humphreys Executor. So the court considered that element to be critical in reviewing the structure of the CFPB. Well, you could just as easily apply that analysis to the FTC today, because that is in fact what the FTC does, right? It has enforcement authority. It seeks monetary penalties against private parties in federal court, which kind of raises the question of, does Humphreys Executor still hold relative to the FTC? And I think you could make a pretty strong argument that at least on a couple of the elements that were dispositive in Humphreys' Executor, that it doesn't.
And I think you've touched on this a little bit in that recitation, but it strikes me that we've talked about what happens when the FTC goes against a company or an individual in federal court under 13B, and they seize assets and they basically freeze you in place. But if you had a Seila Law type argument, a separation of powers argument, and the FTC took you to administrative hearing before their own administrative law judge, what happens then? How do you get that issue before a federal court?
That's a really good question, and I'm not sure there's a clear answer to that, because I think you're stuck until you get out of the administrative process and you get into federal court following that outcome. But it would be interesting to see how you would have to frame up that argument, because you'd be coming into federal court appealing an administrative process that was essentially complete, but then you would be arguing basically afresh that they had no right to do the process in the first place.
And so you couldn't, and I guess the way this is coming up, and I've seen, is that a company is dragged before the FTC, it's administrative hearing. They start the process there, which can be both expensive and lengthy. It's not, one of the reasons for administrative agencies is we thought, or at least the theory of them was, that they would be quicker and more efficient, and everything would be cheaper for businesses. And we've heard this a lot, but that isn't what I hear from clients about the FTC procedure. But if you raise a constitutional problem before those FTC hearings, the ALJs just, hey, we've got no power over constitutional issues. So you've got to go through the whole rigmarole at the FTC and then appeal it to one of the circuits. But you gotta not settle, right? And what do businesses normally do? You've got to not settle the case. You've got to go all through the hearing, and then you get to an appellate court in the sweet by and by. Some companies have tried to go directly to court, and I think there's one before the Ninth Circuit right now, the Axon case, where they've appealed this very issue, where they said, hey, look, I want these issues, these constitutional issues, addressed by the courts, because the FTC doesn't have any power over this. And the district court disagreed and sent everything off to the FTC. And now they're before the Ninth Circuit, and we'll see how that bears out.
Yeah.
But it does show one of the protections the FTC gets to pick. They get to pick whether they take you to federal court or their own agency. And if you go before them, any constitutional issues will have to wait after this long process. So my question I have another question about Seila Law and that line of cases. Do you think, from what you've just told us, that the FTC is skating on thin ice on some of these separation of power issues?
From a legal theory standpoint, it seems highly questionable. And I could definitely see some interesting law review articles coming out of this. From a practical standpoint, we've been living in this world for 100 years, and it would take a lot of stamina and a court that was willing to really look at these hard issues to get anywhere with it. And so practically speaking, I'm not sure, but it certainly raises some very interesting tensions on a constitutional level.
And I guess that hesitancy is, even in Seila Law, the court found that the single administrator had to be employed at the pleasure of the president, but they did not strike down the whole agency. They simply rewrote it to ensure that the agency went on.
Well, that's an interesting point too, because in the Seila Law case, that provision was severable, right? Because it was new and it was discrete. And so the court could strike that provision without actually striking at the trunk of the agency. In the FTC case, if the court were to revisit Humphreys' Executor, that goes way back to the basic underlying structure of the agency in total. And so severability would be a relatively easy legislative fix, but it would be a difficult thing for the court to do without basically taking it on themselves to rewrite the law.
And which they sometimes hesitate to do.
Right.
And I want to get back to one of the issues of equity that we were discussing, equitable powers and injunctive powers. Mm-hmm. And one of the things that strikes me, and it struck me about the Liu case particularly, is the court didn't seem to care what the equitable power was called in the SEC case. I mean, yeah. They didn't, and here they're going to have to say what an injunction is right. In the two cases in Credit Bureau and AMG that they've taken up. Did it strike you at all that the Liu case was a little cavalier about the elements of equity?
Yes, and before I kind of go back and give my dissertation on this, if anybody's really interested in this issue, I would direct you to Justice Thomas's dissent in Liu, because he does a really good job of laying out the historical underpinnings of equity and what is equity and what's not equity. But from an FTC perspective, and we had this come up in our case, a portion of our case that we appealed to the 11th Circuit, it becomes important what the relief sought is called, because you run into issues of tracing and so forth. And so here's what I mean by this. Equitable relief is supposed to be remedies that were available in Chancery before the courts of equity and the courts of law were merged. And so, and this is a lot of what Justice Thomas touches on in his dissent. And so at that time, there were a couple of forms of equitable relief that bore the same name. And so there's something called restitution. And the court gives a very good explanation of this also in the Great West case, where it explains that restitution comes in two forms. You can either have equitable restitution, which basically means someone took my thing, I want my thing back, it's restored to me, that's equitable restitution. There's also something called legal restitution, which is someone took my thing, they don't have it anymore, maybe they sold it, I get the money from that sale, but what I'm getting back are dollars, not the thing itself. That's legal restitution. And it's pretty easy to tell the difference between these things, because legal restitution is the same as what you would consider to be legal damages. Somebody gives you money instead of the thing itself. But in both cases of restitution, there's something called tracing, which means that the thing itself, or the res, if we wanted to, go to the Latin, has to actually be identifiable, and you have to be able to lay your hands on it to get it back to the person that it was taken from. So to get to equitable restitution, you have to be able to identify the res. And the FTC makes a practice of mixing those terms. And so it will claim that it's seeking equitable restitution, but what it's actually seeking is legal damages, because what they want is the money. So, oh, okay, go ahead.
Well, I'm just going to say, just to sharpen that point, they asked for joint and several liability,
right,
which is a hallmark of law. Right. They asked for money from your other assets. So let's say you arguably defrauded someone, or you did defraud someone, and you've that money's gone, but they say they can get that money from any bank account, which is normally what happens when you get a legal judgment.
Right. And even more than that, they can get a personal judgment against you that has nothing to do with the assets in your possession today. It may be you get a judgment against you that you have to pay off over time out of your future earnings doing some completely unrelated job. Now, that type of judgment in no way resembles a traditional equitable relief, because it's not even taking a loose definition of tracing. It's getting a judgment against assets that don't even exist yet.
And in fact, this, for administrative law and actually cabining the powers of an agency. So you have these problems with the FTC. We've talked a little about its structure. It has a multi-panel commission, staggered terms, and then it has its statutory powers, which are pretty broad. The Congress has given them a lot of powers, but they don't seem to be content with it. And in this area, when you have, they call it equitable, even though they're only allowed injunctions, not equitable. And then they seek things that seem to have the badges and incidences of law. Is there a Seventh Amendment attack to be made on this practice?
Yes, and we've raised this issue in court, and other parties have as well.
Just so everyone knows what I'm talking about when I say the Seventh Amendment, I mean that the Seventh Amendment requires jury trials for these amounts of money at law, and anything over $20. So that's what I'm talking about.
Right, and the case law on this is not helpful at all. The argument is very straightforward. The Seventh Amendment guarantees you a right to a jury trial when the damages exceed, I think it's $25,000. But in these cases, we're talking about money damages of millions of dollars. So there's no question that the monetary awards that they're seeking would easily satisfy the Seventh Amendment. But here's the problem that people who've raised this issue have run into, which is the FTC Act only allows for injunctions. An injunction is indisputably a form of equitable relief. Next, the theory says, well, courts have inherent equitable authority to grant complete relief, and so any relief that they grant ancillary to injunction must by definition be equitable. And then the opinions will say, well, the FTC can only seek equitable relief, therefore any relief that they get is equitable. so you go around the circle. And so even if you have a situation in which the monetary award, by all its independent indicia, is legal damages, which should allow for a jury trial, there's, in the FTC world, a completely separate body of law, which basically goes around that circle and says, well, if the FTC is getting it, it must be equitable, regardless of what it looks like.
Because that's all they can do, right?
Right, and so no jury. Right.
So, and I do think, it's my hope anyway, that some of those cases also get a hard look, the way the Seventh Circuit looked at its precedent, because the sleight of hand here is that the federal courts have certain powers and abilities. But the FTC doesn't have all the powers and abilities of the federal courts. They're allowed to ask for certain things and not ask for other things. But it does, once again, and this concerns me about the Liu case, when they didn't mention the word res, and they sort of just waved their hands around and said equity, that some of what you're saying does seem to still be in at least some of the justices' minds.
So the thing about the Liu decision that actually kind of muddies the waters is that Liu clearly decides that disgorgement is a form of equity that the SEC can pursue. But the thing with disgorgement is, traditionally, disgorgement has been intended to bring the defendant back to their starting position. So the idea is to prevent somebody from being unjustly enriched. It's not to bring the plaintiff back to their starting position, which is what you would get with restitution. And so the outcome of this case is that they're saying, well, disgorgement is a form of equity, but it doesn't require tracing, because the decision in Section 3, where they run through the guidelines that the lower courts may consider, allows for the potential of joint and several liability in the case of partnerships, for example, potentially among married people. And so there's no tracing requirement flowing from Liu. And I think you could at least make a plausible argument that Liu eliminates the tracing requirement and allows for disgorgement without any form of tracing at all, which makes it completely different from what restitution has traditionally meant, which is that you have to find the res before it can be restored.
And by tracing, I think I should say for everyone's benefit, you mean tracing the money from the wrongdoing through a pipeline, not having it mixed together with any other funds, and then tracing that money to wherever it is now and giving it back to the person it was taken from.
Right, exactly. And there are some, there's a little bit of wiggle around the edges. So for example, you take money to the bank and you deposit it with the bank in trust for the bank to purchase you, I don't know, a bond or something. And then the bond, the bank doesn't purchase you the bond, and you say, I want the money back. The bank then cannot say, oh, well, we put the money into the general account, you're never gonna find it again, too bad. Because there's something called a constructive trust, which is you hand over a certain amount of money for a specific purpose. That type of scenario still falls under equity, but it's very specific and it has very defined edges. As opposed to, for example, you go to a business, you pay for something, they take your money, they then spend it for, keep the power on, pay for raw materials, and so forth. It's now gone into the general stream of business. Now, if you sue them for, whatever your injury is, the money that you get back is not the money you gave them. It's money that's equivalent to your injury, and that's legal damages. And so there's no tracing there, as opposed to like you go to the dry cleaner and you say, I want my shirt back. They give you back the shirt you dropped off, not just any old shirt. Right. That would be restitution.
And that is, here at NCLA, I mean, one of the problems with the administrative state is that they're given specific powers and they keep creeping into these other powers and just waving their hands around and calling it equity. But I think practitioners may be interested. I think what you're talking about here is the Vilatech case. Can you just tell the audience what the 11th Circuit found in that case and what happened? Because it is an example that there is an ability sometimes to get the courts to focus on what the FTC is allowed to do and what it's not allowed to do, and maybe give defendants and people subject to these type of investigations or prosecutions, really, some relief, and at least know what they have to prove and what they don't have to prove.
Right. Okay. So in the Vilatech case, when the FTC came in and sought the asset freeze, the first step was that they wanted the assets of the companies, the defendant companies. And there's a certain amount of logic to that, right? The next step was that they wanted to freeze the assets of the two principal officers of the company. And so they froze all of their personal assets. On top of that, they then sought an asset freeze on the spouse of one of the officers. Then they also named as a defendant the brother of one of the officers, and then took the additional step of freezing the assets of the brother's employer. Now, if this is a little hard to follow, it's because now we're 4 steps removed from anyone who had anything to do with something that the FTC could or should be investigating. And so part of our initial approach was to appeal this asset freeze to the 11th Circuit relative to the spouse and the brother's employer. And the 11th Circuit found in our favor relative to the tracing issue, which was you can't go after the spouse and say, well, any money that you have you derive some benefit from the person you're married to, and so we're taking all your assets as well. The court said, no, FTC has to demonstrate that the assets in the possession of the person that they're targeting actually came from the activity that they're alleging was problematic. And so this is an interesting point and something that concerns me a little bit about Liu, which is that the 11th Circuit's ruling in our case was on a restitution theory. And so the court required tracing because restitution requires tracing. But now, after Liu, if the FTC characterizes their monetary demand as disgorgement, I think they could reasonably argue that tracing is not required. And so while the disgorgement definition is potentially narrowed by having to give credit for expenses, and so it should be a smaller dollar amount, the offset to that is that I have doubts now whether tracing is actually necessary in these cases.
Well, it depends on it. That's an SEC area, but I would still argue the FTC doesn't have the power to do any of these things.
Well, right.
But and the other issue is, I don't think, it strikes me that Liu doesn't preclude a circuit from requiring tracing. They just don't deal with it because they just said it's all of equity. Somewhere in equity, you might be able to do this. Right. So I don't think it's that strong. Hopefully you will not be proved right on that. So we're going to get to questions briefly, but I'd like you to sum up anything I haven't asked that you think is important to the cabining the FTC power or addressing FTC's overreach on administrative law questions that I haven't asked you. And if you want to just sum up before we go to questions, I'd love to hear it.
Well, my hope coming out of the AMG case is twofold. The first is that the court makes a very strong showing that an agency only has the authority that's been given to them by Congress, and that they can't just take a statute and reinterpret terms to expand their own powers and basically create an entire new world of authority that Congress didn't contemplate, or at least didn't include in the wording of the statute. That's the first one. The second one, which is possibly a pipe dream because I'm not sure it's necessary to the opinion, but I would love it if the court would come back and clarify what is equity and what is not equity, because they've done it in the past, particularly in the Great West case, but the lower courts have largely accepted the FTC's arguments that, well, equity is equity, and we can call it by a variety of different terms depending on which term gets us to the biggest number. And that just makes it really difficult for anybody to know what the law is.
And I am thinking a little bit about Gorsuch's opinion in the Oklahoma Bowie, I think, which is the case where he says that wrongs done a long time don't become the law. So I'm hoping of citing the FTC area as we go forward. I want to thank you for this presentation, and I'm going to see if we have any questions. I'm new at this, so give me one moment. Take a look at there, and I'll look over here.
We don't have any questions in the queue yet, John, but we certainly invite our participants to go ahead and submit some questions.
All right. And while we're waiting for questions, I will say I think that the courts have had some ability to lately to say to the FTC, you've gone too far. They did in the Violatech case. That was out of the 11th Circuit. The Third Circuit had a case whose name I always forget.
Right, the Shire Virapharma case.
Shire Virapharma said, hey, look, you can't, there's no evidence that there's going to be continuing harm. There has to be continuing harm.
Right.
And the FTC had not had its feet held to the fire on those matters. And so I think that was pretty important. And so, and then recently, of course, they've also said, hey, look, your injunctions have to tell people what they're actually allowed to do and not do.
Right.
So I don't think there's any reason for despondency. The courts have at least been looking at these things anew, and particularly the credit bureau case. I didn't see it coming out of the Seventh Circuit, and it was certainly welcome.
I'm pretty hopeful, actually, because the fact that they took these cases after Liu, I think, is a pretty strong indication that they consider them to be a different structure. There's at least something there that must be addressed. And so I'm pretty hopeful that they put a stake in the ground and say injunction doesn't mean injunction plus whatever else you want.
Well, I have a question, Adi Dinar of NCLA. I would love your thoughts on the FTC's antitrust cases and the DOJ's antitrust division and the turf war between these two. I'll give you I have my views, which I will share with the audience in a moment, but go ahead.
I'm not really an expert on antitrust, so I think I'm just going to defer to your comments.
I will do this. The so-called turf war in the antitrust area is very interesting, because what we're seeing is, particularly out in the Qualcomm case in the Ninth Circuit, when the FTC took a different view of antitrust law and its relation to patents than the Justice Department had. So you have the Justice Department, which is supposedly the premier enforcement agency, and we'd think that businesses would want to know whether the Justice Department's going to come after them. And the Justice Department saying, "Oh no, you can't. This patent, I'm not. It's a difficult issue of patent law and divestment and undoing things." But the fact is, they had different views, and that makes a big difference for particularly tech companies. And the Ninth Circuit is a hotbed of tech companies, of who's going to get sued and who's going to come under this, whether justice comes for you or the FTC comes to you. And it strikes me that although they normally work these things out between them, that they shouldn't really. There should be some arbiter rather than the court for when two areas of the executive branch are at odds. You would think there being one executive that someone could fix this problem, but it just continues on.
Well, it's sort of interesting because you think about, DOJ has to cover a lot more ground than the FTC. And so when you have comprehensive regulatory schemes in other areas, the DOJ has to reconcile its approach to each of those areas, whereas the FTC is a little basically paddling its own canoe.
So I've got two questions. One is, someone has asked me about the Axon case, which we did do. NCLA did an amicus brief in that case, and that is the case that I was alluding to, where they have an antitrust issue. Axon bought a company. It's most well known for making tasers, and it bought a company, and the FTC decided to come after it for antitrust reasons. And a year later, after the merger went through, they're trying to undo it, and also demanding Axon now give patents to this new company that it once spun off. Not even the patents it got, but new ones. So the company decided to take the FTC on directly and brought a suit against them on constitutional issues, saying, look, we don't want to be in the FTC's administrative process because we think that the separation of power is no good. We think that the separation between the Justice Department and the FTC on antitrust creates tremendous due process problems. The whole preclearance, it creates all kinds of due process problems. And what are they going to do? If they go to the FTC on that, the FTC is going to say, not my project. You'll have to wait for the appellate court. So they tried to get it in the district court, and it was dismissed. And so that's on appeal in the Ninth Circuit right now. And I believe it will be argued this week, Friday. But that's one to watch too, because since I was asked about the antitrust division between justice and antitrust, this is an important one. Now I have a question. It is so frustrating that there is no penalty for FTC, DOJ, etc. employees when they bring unjust accusations, especially against small people, referencing License to Lie by Sidney Powell. The expense make justice out of reach most people and companies. And Sidney Powell had a big win in the Flynn case, although the judge seems to be contesting it still right now. I'm familiar with her. I didn't read the book though. But this is another area of that NCLA is interested in, and anyone who's interested in the administrative state. Qualified immunity and immunity issues for government employees are a hot topic right now. The immunities provided for many of these public employees is just judge-made law. It hasn't been created by statute. Sometimes it's created by statute, in which case, talk to your legislature. But sometimes it's just something we've always done, and it needs a new look as well. But I don't think that there's anything that can be done about it. But the prosecutorial discretion is quite broad, and so pretty much all you can do is write articles and blogs and say this happened to me, because you're not going to be able to sue anyone.
I am hopeful, though, that if the Supreme Court puts an end to the pursuit of these large monetary awards, that a lot of this will just go away naturally. Because just my observation is that a lot of the bad behavior is due to pursuing the money. And if it was really just a narrow focus on modifying someone's behavior, then a lot of that motivation would be gone. And it to a large extent, I think, would heal itself.
Much like civil asset forfeiture,
right?
We see the behavior of the law enforcement change when the money isn't going to go to them, right?
Right.
And the FTC does love to put its what I'll call its marquee number, which is not the number they got. It's what the court said you could get this, and then if they just collect $1, it's still the marquee number on their website. So it does seem to interest the government employees that are making these decisions. Well, if we have no further questions, Judy, do you see any? I don't want to shortchange anyone.
Oh, Mike.
There is one that just came in.
Oh. Okay. From Michael Pepsin of AFPF. Say the Supreme, I'll choose number one, Cindy. Say the Supreme Court agrees that the word injunction as used in Section 13B does not mean money damages. What about defendants who are already subject to monetary judgments or consent orders they cannot pay? Will they be able to get relief under Federal Rules of Civil Procedure 60? And he has B56, but I'll just use 60 because I'm old and I remember that's when it was by its own.
I have actually wondered that myself. And what I would anticipate happening is that for people who are in a position where there's a judgment that's been suspended or that they're working off, I would expect a lot of people to challenge those judgments. For people whose judgments are complete, I don't think they probably have, probably wouldn't have too much luck there. I
think they would if they came after. I think if you could, if a new Supreme Court case came out and the judgment, and they were still going after you for it,
yeah.
Then it would be very easy. The question is, what if they're not doing anything, but it's hanging over you?
Well, and the other question is, what if it was a consent judgment, right? Because for most of these people, they end up settling because they just can't take it anymore. And so at least allegedly freely agreed to these settlements. And so having agreed to it, they're not on.
Right. It's a settlement.
Right. It makes
It's
it, that would be
enforceable against them.
pretty hard to.
You can't say, I didn't know the Supreme Court was going to come out with that. So they did. So please relieve me of my agreement. And that's another issue.
Right.
All right. Well, I have one last question, which is there anything else to watch in AMG and credit bureau? You've mentioned two issues. Are there any other issues that may bring up, if not from the parties, maybe amicus, that may come out of these two cases that they've combined?
I don't necessarily expect this to come up in the argument, but I personally am very interested in the effect of the decision on the presumption that elements of proof they basically just get assumed into existence. To me, that seems like a huge, huge problem, that the FTC can walk into court and basically all they have to demonstrate is that somebody made a statement. Well, usually the fact that somebody made a statement is undisputed. It's all the other elements. You know, did somebody actually hear it? Did somebody actually see it? What did they actually think when they saw it? Did they rely on it to their detriment? Were they actually damaged in some way? And my hope is that if the money motivation gets taken away, that some of those problems get resolved. But I think in the end, that probably those are going to have a more solid judicial resolution, because the notion that you don't have to prove your case in any meaningful sort of way seems like a real problem in terms of a rule of law issue.
I think you're right there. And I will say, I just want to note, we have some follow-ups on Seila Law, and there are issues that Axon has brought up on whether or not these administrative law judges are properly appointed. I hope the court takes that up again. Some are percolating through the courts right now. But Cindy, I want to thank you for being here. This is our first luncheon law that we've done remotely. And I thank you very much for being our guinea pig. I appreciated it. And I hope all of our listeners and viewers have appreciated it as well. We will go forward and be doing these luncheon laws, which are like those that we normally have here at NCLA, except you buy your own lunch at these. So I want to thank you again for being here, and we'll be watching any amicuses you put in, and I ask anyone to be looking at our amicuses here as well, because it looks like it's going to be another big term at the Supreme Court. Thank you, everyone, and we're signing off.